Hello, my name is Ron Tasoff. I'm a partner in the immigration law offices of Tasoff and Tasoff. We're probably one of the oldest immigration law firms in the country, started by our father back in 1949. I'd like to tell you a little bit about H-1 visas. H-1 visas are a great step from coming here either as a student or a tourist to getting a green card based on specialty, based on job skills, or one of the other categories that skilled and professional workers might qualify for. To qualify for the H-1-B visa, you need either a U.S. bachelor's degree or the foreign equivalent of a U.S. bachelor's degree. In some countries, this might be a master's degree. What we usually do with foreign degrees is get an academic evaluation, and that way before we submit the application we know for sure that our client is qualified for this benefit. The other thing you need is a job offer, and this job offer should be from a company that can legitimately employ someone in a position that requires a college degree. Now, how do you find out if a position requires a college degree? Well, the Department of Labor has helped us to some extent by setting up an occupational table where we can see what the minimum requirements are for any specific occupation or job title. And if they say that it requires at least a bachelor's degree, then we can be pretty confident that we can use that as a occupation that would qualify for an H-1 visa. I should also mention that there is an exception to the requirement that you have a bachelor's degree, the so-called 3-for-1 rule. This allows us to show that our client has the equivalent of a bachelor's degree by using experience. The rule basically states that for every year missing a formal education missing toward the bachelor's degree, that year can be substituted by 3 years of progressive experience. Thus, if you have a 2-year AA degree or gone to college for the equivalent of 2 years, and you have 6 years of progressive experience, then you would have the equivalent of a bachelor's degree. Although we do have to document that experience quite specifically, and oftentimes we get an evaluation. The process is relatively quick. We do need some time before we file the application to get what is called a labor condition application. In this application, the employer is stating that he doesn't discriminate against American workers and that he is paying the prevailing wage, that is, the wage that an American worker would be making in that geographic area. This is determined by various charts that we can get from the Department of Labor and other surveys that we can use that provide that information. The job does not have to be full-time. It can be part-time, and we recommend usually that it be at least 20 hours to qualify. One consideration that every applicant has to keep in mind is that there's a limit to the number of H-1 visas that are issued each year, and the earliest you can apply for an H-1 visa is on April 1st. That's 6 months before the federal fiscal year begins on October 1st. It used to be that pretty much all H-1 applications that were approved for the following year, that would be the year starting in October, would have to be filed on April 1st. With the recent recession, that date has moved back, but it seems like as the economy improves, it would be wise to file your application, if at all possible, on April 1st or shortly thereafter, because it's more likely that the quota will be closing sooner and sooner after that April 1st opening date. One of the great features of an H-1 visa is that it's valid for up to 6 years and can be renewed actually pretty much indefinitely until the applicant gets a green card. Initially, you can get 3 years, and then there's a renewal of an additional 3 years. But if by the end of your 5th year you file a labor certification application, which is the first step to getting a green card based on job skills, you're allowed to renew that H-1 visa until you're issued the green card. One of the great features of an H-1 visa is that you can change jobs and continue your employment authorization. Basically, as long as you're in status, which means that you're working for the first employer, a second employer, a new employer, can file a petition on your behalf, and you can start working for that new employer as soon as that H-1 petition has been filed. It doesn't have to be improved. This is called porting, P-O-R-T-I-N-G, and it allows H-1 workers to go from one employer to another relatively seamlessly. There is one trap, though, and that is you have to be in status when you apply for the new job. And to be in status means, for the most part, that you're still working for the old employer. So you have to more or less have the cooperation of your old employer, or oftentimes you get the new job and have the H-1 petition filed, and then you give your 2-week notice, even though you can start working upon the filing of that petition for the new employer. At Tasoff, we do a lot of H-1 visas. As I mentioned previously, it's a great vehicle for allowing our clients to go from F1 student or even B2 tourist to permanent resident based on job skills, while having that gap of time that it takes for the quota to be reached on most of the job preferences, having that time filled with a visa that allows our client to work in the United States and indeed even change jobs if necessary. The only disadvantage perhaps of the H-1B visa is that the filing fees can be quite expensive, and thus you need to have the cooperation of your employer, since a portion of those fees have to be paid by the employer. The H-1 visa, as you can see, is one of my favorite visas. If you have any questions about what I said or any other questions about H-1 visas or immigration law, feel free to give me a call. Our telephone number is on the website, 818-788-8900, and I'd be happy to talk to you and answer your questions free of charge.